This is Bloomberg Law with June Grasso from Bloomberg Radio.
We're going to work with President Trump to push back on governments around the world that are going after American companies and pushing to censor more.
Meta's Mark Zuckerberg has been courting President Donald Trump since his election, scrapping his platform's content moderation policies on Facebook, Instagram, and Threads, donating $1 million to Trump's inauguration, and visiting the White House several times in recent weeks. Despite all that, the historic antitrust case against Meta that was started in the first Trump administration went to trial this week in Washington, D.C., as the Federal Trade Commission tries to force Meta to divest Instagram and WhatsApp. And Mark Zuckerberg was the first witness the government called. Joining me is antitrust law expert Harry First, a professor at NYU Law School. Harry, what's the main issue the FTC has to prove here?
There are a few main issues. The first issue is the definition of the market. So the question is, who are Facebook's competitors? That's sort of, in some ways, a simple question. Who will consumers turn to? What sellers? If the seller they're looking at offers a bad deal, usually it's raises price, they switch to something else. We do this all the time. So the question is, who are the rivals of Facebook, and who do consumers switch to if they wanted to switch? Market definition, always critical issue in antitrust cases, and the first issue to resolve. Second issue is, are they a monopolist in this market? Do they have a large enough share of the market? Is it hard to enter the market so they can sort of have power to do what they want? Do we see them doing the bad things that monopolists do, which often means, selling something at a high price? Of course, Facebook says, hey, we give our thing away for free. So what's their problem? And then the third thing is, okay, if they are monopoly, with monopoly power, have they engaged in anti-competitive conduct that excludes competitors unreasonably from the market, engage in some exclusion? And so that's the third thing, and that's where the acquisitions of Instagram and WhatsApp come in.
Let's start with the market definition, which was one of the key points Zuckerberg was questioned about. So tell us how the FTC and Meta are viewing the market.
So the big argument is, does Facebook compete with YouTube and Twitter? Because YouTube and Twitter have huge numbers of users, and Facebook contends that the market is, whatever it was maybe in 2011, now there are lots of competitors, and Facebook is doing things similar to particularly TikTok. So the Federal Trade Commission has called the market, we always love these names in antitrust, the Personal Social Networking Services market. And then they use an acronym so you think it's something special, the PSN market. And basically that's friends and family, where Facebook started out, putting people together and creating the social network, as the name of that movie was way back at the start. So this is the market now updated by name, Personal Social Networking Services. And the Federal Trade Commission says that's really the core of their services, and it's not something that actually other platforms except for Instagram offer. They don't really offer that sort of friends and family network. TikTok doesn't really follow people, but it's, not for keeping up on what your high school buddies are doing. So the first question is, how broad is that market? And it's complicated by a couple things that Facebook's done. They do have a chat function, Messenger, so that might bring in, other, chat platforms, Apple, for example, or they do have Reels, which are, these short videos. Of course, that's TikTok. And that was an effort to compete with them. So Facebook says, hey, lots of choices for consumers. They don't want to watch Reels on Facebook. They go to TikTok and vice versa. So we have to include them in the market, says Meta. And, that's what a lot of the argument's going to be with data and consumer surveys and so forth. And the analogy that the Commission has used, and I think will continue to use, is supermarkets. So there was a famous case involving Whole Foods and an acquisition that Whole Foods did, and the market that the Federal Trade Commission called it and that they won was the PNOS market. Got it? Premium, natural, organic supermarkets. And when Whole Foods made this acquisition of another market like that, they said, aha, that's the market. Other supermarkets are not in this market, like Stop and Shop and so forth. And the court in which this case is being tried, the D.C. Circuit, accepted that definition. And the point is sort of a simple one. Yeah, they've got lots of things in the supermarket, but you go to certain supermarkets, sort of a core of users for a core of things. So you go to Whole Foods because you like to pay high prices. Oh, wait a minute, that's wrong. You go to Whole Foods because you want the organic, natural, premium stuff that they specialize in, and then you buy milk. So, you go to Facebook because you want to communicate with your friends and family. And then, maybe you'll look at some reels or maybe do some other things or watch whatever other feeds they've got. But the core is still that. So that's going to be the legal and sort of factual contention that the parties are going to litigate over during the course of this trial.
Yeah, and Zuckerberg said that Facebook's feed has turned away from family and friends and toward, quote, more of a broad discovery entertainment space.
Right. Yeah. Yeah, we compete with television, and tennis and the National Football League. Well, they're not going to go that far. But, the game, if you want to call it that, but the idea is you broaden out. Consumers do have lots of choices, do different things, and they don't only look at Facebook. And Facebook over time has tried to bring more things within its ecosystem, within the platform, and to keep people centered on Facebook. So they've gone into virtual reality. That's why Zuckerberg renamed the company Meta, because he wants the metaverse. So true that, but that doesn't take away from the fact that they still sell groceries. They may want to have espressos, in the grocery store, but they're not an espresso store. So, they still sell their core function, and that's why people put up with all the junk, pardon my French, that they see with these ads constantly. You can barely find things, thumbing through all the ads that you get fed. So people still stick with that.
So how do you show that Meta is a monopolist?
Yeah, this is a good question. A normal way is by what is referred to as the structure of the market. So what's their share of the market, and how easy or hard is it for others to enter the market and reduce their power? So if it's very easy to enter and you have 100% of the market, you don't really have much power because someone can come in tomorrow and just wreck your plans. So you sort of look at both things, and they'll measure shares by daily average users and monthly average users, DAWs and MAWs. How long do people stay? What's their engagement? They've got all sorts of data about that. And they're going to fight over how much of that time is spent on friends and family and how much of that time is spent on, let's say, reels or advertising or the news feed or whatever. And so maybe the share isn't so large. So they'll look at market share. The judges already in the past have refused to dismiss the case on sort of argument that they don't have a monopoly share. But you have to work through the facts and now convince the judge with all the data. And how easy or hard is it to get in? Well, when was the last time you tried to start a PSN company? It's pretty tough, given the number of users they have and the unwillingness of people to, sort of move all their photos and information to some other platform. There's another way of proving it. The other is you act like a monopolist. You have high prices. So since there are no prices, the Federal Trade Commission is saying they take it out by degrading the product. They don't give us the privacy we'd like, and they increase the ad load. So you get more and more ads. That seems like an easy one to me for what little I use Facebook. But there'll, I assume, be some evidence and testimony about the extent to which, over time, Facebook serves its users who think they're getting something for free more and more ads that they've got to go through, and maybe they'll click on. Facebook says, hey, that's a service. People love ads. I'll leave that to the judge to decide. But
yeah, in the opening statements, Meta's attorney said, Quote, a lot of people find them useful, even entertaining. I guess I'm just not one of those people.
Yeah, advertising, is information. But good Lord, ad load is just, well, anyway, they can argue over that, and they're going to, make those arguments to the judge. But it strikes me as a heavy lift for Facebook at some point to say that all these ads, which we serve you because you happen to have clicked on one thing and then that's all you see for a while, that's a great thing.
Stay with me, Harry. Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Harry First of NYU Law School. How important is Zuckerberg's testimony? And if the judge finds against Meta, might Trump step in? I'm June Grasso, and you're listening to Bloomberg. I've been talking to Professor Harry First of NYU Law School. Harry, the FTC has some smoking gun emails from Meta executives, including Zuckerberg, particularly one from 2012 where he described the Instagram deal as a way to, quote, neutralize a competitor.
Yeah, that's a good one. I could see the lawyers looking at that going, oh, my God, Zuckerberg, why did you write that? There's a good reason why that would be called a smoking gun, because it shows, not every acquisition that a major platform or a monopoly, let's say, makes is illegal. It's not illegal for that reason. Firms make acquisitions all the time. The ones that are illegal in this context are those that are done to snuff out a threat to the monopolist. It's as they said, a buy or bury strategy. They would just buy up the competition they were worried about. So on its face, it could be neutral. Well, they made an acquisition. What the heck? And maybe they have some alleged good reasons. But then you read the email, and Zuckerberg says, "Hey, we're worried about this company. We better buy it." And their effort at incorporating photographs into Facebook and making it the kind of thing that Instagram was doing was not going well. So they were really being challenged by Instagram. And, they responded to that challenge, not by making a better product, but by buying their competitor. Classic move, but not a competitive move. It's an anti-competitive move, so the government says. And so Mark Zuckerberg apparently said.
Is Zuckerberg the most important witness or not, really?
It's hard for me to say exactly. I'm sure that Sheryl Sandberg, who ran a lot of the business, will be a very important witness. I mean, they have flashy emails from Zuckerberg, and I don't know who maybe some of the more current operating people, because one of the things, sort of as a psychological point, I think the commission's going to make, it's not a question that was then and this is now. It's a question of this is always. So they got their monopoly, they maintained it by these acquisitions, and then they've stuck as a monopolist, not as a real competitor. And, maybe their platforms have changed over time a little bit, but it's still the same basic playbook that they're following. So I'm looking to see, some that more recent testimony and some other executives, I have to say, but particularly Sheryl Sandberg.
And Meta is arguing that Zuckerberg's past statements are no longer relevant because of competition from TikTok, YouTube. And
yeah, that was then, this is now. So, he wrote that then, and maybe he was concerned, and maybe should have been, maybe shouldn't have been. But, now the competitive environment looks very different. And, we're in a world where, particularly TikTok, but also YouTube, consumers have lots of choices when they, look at these media. And less as the choice because I want to be sure I'm in, a friends group with my grandma. I want these quick entertainment reels. I'm following performers. I want to know, how to do something. And so the attention, which is, in some sense, what the limit is on what people can do, attention has shifted from, your father's or grandfather's product, which was Facebook, to, these other alternatives.
Where does it fit in that the FTC had a chance to challenge the deals for Instagram in 2012 and for WhatsApp in 2014?
Well, so first of all, legally, it doesn't matter when the Federal Trade Commission or the Justice Department reviews a merger before it's consummated. All they do is look at it to see whether they want to bring suit then. They don't approve mergers. So in some sense, it doesn't matter that they passed at that time, but it does cast a psychological pall a bit over the case. Well, if it was so obvious that this was, trying to snuff out a nascent competitor, how come you didn't see it? Both of them? It's not like these things, they didn't come across your desk. You had never heard of Facebook. So I think that's part of the pull, even though that doesn't matter, and it can later turn into something that was anti-competitive. So what I assume that Facebook will try to do is to say, well, that wasn't the deal then. It wasn't clear they were nascent competitors. You don't want to quash companies from acquiring small companies. That's important for innovation. And now to turn around, a decade plus later and say, guess what? Now we don't like it. Maybe that's not the best approach to antitrust. And it may come up, particularly even if it doesn't come up on liability directly, I'm sure that it's going to come up on remedy when they get to that. That time will be an important part of the theme in remedy if Facebook does lose a trial.
So remedy, speaking of remedy, is it an existential threat to Meta, or more than that? Estimates say that it earns about half of its advertising revenue from Instagram.
Well, I don't know the exact numbers. That sounds plausible. And I don't know the extent to which those numbers are U.S. only. Facebook's worldwide. So an existential threat, probably not, but maybe a threat in terms of future development of AI. I don't know. It's obviously important. They certainly are fighting hard to hold on to both of these acquisitions. So if they do lose on liability, that's sort of an obvious remedy, but not necessarily going to be the one the court will accept. So the threat is a potential threat, important threat, but there are lots of steps before we would see, an order to separate those companies.
Because a breakup of that size hasn't happened since AT&T 40 years ago?
Well, we haven't taken on companies of this size. We did take on Microsoft, didn't order structural relief. The AT&T breakup was by agreement. It was a result of litigation in a sense, but it was not a decree entered by a court after losing a case. So we don't do divestitures that often. Not never. It does get done, but this is certainly of an important magnitude and, puts the court in a difficult role of trying to separate companies that Facebook, frankly, has done its best to smush together, to use the technical term. So I think that their operations are very integrated, in part as, I think, probably a conscious effort to make it harder to disintegrate them. So, it would be difficult. There's a famous line that divestiture is a remedy, not a penalty. And Judge Learned Hand said that after the Alcoa case. So even if they broke the law, quote unquote, found to have violated the Clayton Act, that doesn't mean that, the government is entitled to this remedy. They still will have a tough fight to get the court to do this.
Can we read anything into the fact that Judge Boasberg has sounded skeptical about the FTC's case? He dismissed the initial case in 2021, and in November he said the agency faces hard questions about whether its claims can hold up in the crucible of trial.
Right. Well, he's running the crucible, so like an Arthur Miller play. So Judge Boasberg, just from reading his opinions, is sharp. He's critical. He is not a pushover for the government, but he's not a pushover for the defendants either. So, I read this as saying he'll come out with an opinion that will prove challenging for the losing party on appeal, wherever that is. And I don't predict that he's necessarily going to come out in favor of Facebook, frankly, because he's been willing to accept, at least as a legal matter, important arguments from the government and dismissed some of Facebook's defenses. And, you're not going to fool this judge.
Finally, Harry, so suppose Judge Boasberg does rule for the government. Mark Zuckerberg has been cozying up to President Trump for a while now. Could Trump bail Meta out?
I guess the answer is sure. At least at this point, he has pretty much seized control. I don't know what you want to call it, a hostile takeover, whatever takeover of the Federal Trade Commission. He fired the two Democratic members of the commission, the two commissioners supposed to be balanced, bipartisan commission. He's fired the two for no reason other than they're Democrats. The chair is slavish in his praise of the president. Yeah, I think that's a fair word, I have to say. So, yes, I think Trump could very well order whatever he wanted to order, and if the chairman or the other commissioners didn't want to go along, he could just fire them. At least that's how he sees the law. It may turn out that that's not going to be the law. Maybe the Supreme Court is going to not take that final step in terms of ending the independence of regulatory agencies. But we'll have to see. That's in litigation. But if he has control, then he can do that. Even before, he did try to pressure in his first administration, pressure the chair of the Federal Trade Commission, who resisted things. But now the ability and willingness of the chairman to resist whatever the president wants is zero. So we'll just have to see. That said, I'm not quite sure I know or understand, and maybe the president doesn't either, what he might want and what he would pressure the Federal Trade Commission to do. Obviously, he's not pulled the plug on this litigation, which he could have. So we'll just have to see how it goes.
It's always great to talk to you, Harry. Thanks so much. That's Professor Harry First of NYU Law School. Coming up next on the Bloomberg Law Show, it seems like President Trump is targeting blue states. How can they fight back? I'm June Grasso, and you're listening to Bloomberg. Is President Trump's blue state bias showing? Some of his recent actions seem to be targeting blue states, like a Department of Health and Human Services funding cutoff that closed offices in Boston, Chicago, New York City, San Francisco, and Seattle, all cities in blue states. But even if Trump is singling out blue states in his retribution campaign, what can they do about it? My guest is retired federal judge Nancy Gertner, a senior lecturer at Harvard Law School. She's a co-author of a Bloomberg Law Legal Insight piece entitled Trump's Blue State Bias Could Rip the U.S. Apart. Judge, can you start by telling us about some of Trump's actions targeting blue states?
Well, the most recent one was when he closed 5 of the 10 HHS offices. And significantly, the 5 were all in blue states. In addition, he has suspended the funding for various kinds of programs to hospitals, but really he's listening, we believe, only to the red states that are begging for this to return. So there was, Katie Britt from, I think it was Alabama, calls him, to reinstate, and we believe that he will do that. So he's basically doling out federal funds to advantage the red states over the blue. And we think that that's going to be a pattern going forward. The pattern has not been completed. We haven't seen all aspects of it, but clearly this is what we have seen so far, particularly the thing that happened 10 days ago with respect to HHS. I mean, why do you shut down the regional offices that do the most business, namely, New York, Boston, San Francisco, Seattle. I think Chicago was one of them as well. I mean, it's really pretty transparent what's going on.
And what has the Supreme Court said about the federal government's requirement to treat states the same?
Well, in a decision that I mostly disagreed with, which is the Shelby County decision that was dealing with the preclearance requirement of the Voting Rights Act. The preclearance requirement of the Voting Rights Act was a requirement that really reflected the discrimination against Black people that had occurred in certain states in the South. That was documented, that was well known. The Supreme Court eliminated preclearance, which basically was a situation in which the government would review any changes in voting rights procedures in those states to make certain that it didn't continue to disadvantage Black people or didn't re-disadvantage Black people. And what happened was the court eliminated that preclearance requirement on the theory that there was a requirement of equal treatment of all states. And so if that is the principle reaffirmed now only a few years ago, then Trump simply does not have the right to discriminate against blue states in favor of red. He can't use the federal spending power to disadvantage blue states at the expense of red.
I've lost track of how many of his executive orders have been challenged, and many of them have been found to be unlawful or unconstitutional by lower courts. But the administration has not been following all the orders of the lower courts. Have we reached a constitutional crisis yet?
I don't think there's any doubt that we're in a constitutional crisis. Whatever the name you put on it, I don't think that there's any doubt. So far, there isn't a situation, with a Southern politician now barring federal troops from coming into Mississippi or Georgia or Alabama or anything like that. That's not what we have seen yet. But we have seen, as with, for example, the most recent case of Mr. Abrego Garcia. This is the individual who was wrongly deported to El Salvador. What we have seen is the government effectively ignoring a Supreme Court decision. We've seen the government effectively ignoring decisions of the lower courts. We've seen sophistry and outright lying. The sophistry is describing the Supreme Court's decision in a way which is patently false. They're saying things like the Supreme Court, in dealing with the Abrego Garcia case, didn't really demand that the government do anything, that only they can passively make certain that if El Salvador releases a man, he can come into the country. I mean, that's absolutely not what the Supreme Court said. It's not at all what the Supreme Court said. So that's sort of really sophistry in dealing with Supreme Court decisions. And then there's been outright ignoring and disobedience of them. In the cases involving the funding freeze, a court will require that the funding be restored. The lawsuits dealing with the funding freezes on government funds across the country. And the government is just ignoring it, requiring, courts to essentially get to the moment of contempt. So I don't think there's any question we're in a constitutional crisis. When the government can lie, as they did in the Oval Office yesterday in the meeting with El Salvador's Bukele about, again, this gentleman, Abrego Garcia, when the government can lie flat out that he had been found to be an MS-13 member, not true anywhere, that the government can lie about its arrangements with Bukele, I don't think there's any doubt that we're in a constitutional crisis.
You talk about the misinterpretation of the Supreme Court's decision, not only by the Attorney General, Pam Bondi, but by Stephen Miller, who said the Supreme Court ruled for us unanimously.
Right. Again, this is not even close to true. It's just not even. When the Supreme Court says the government has to facilitate its return, and it clearly in the context of a decision that is about how there was no right to deport him, when they say it has to facilitate his return, that doesn't mean, well, El Salvador, if you wish to send him, we will allow him in. It's clear that it meant more than that. It meant affirmative steps to right a wrong. The government was responsible for a wrong, and they had to take affirmative steps to right it. I mean, also, the notion that this is a foreign policy issue is pure poppycock. This is a commercial issue. This is not like returning Brittany Griner from Russia, which was a matter of delicate diplomatic negotiations. This is about a commercial contract between a two-bit dictator and the United States dealing with a contract for $6 million to receive deportees from the United States. And clearly, the United States has rights under the contract, and the United States has power. If in the meeting before the public meeting yesterday, Trump had said to Bukele, return this guy, it would have been over. it would have been over. And the fact that they don't even think that this is a wrong that needs to be righted is stunning.
So in the article, you talk about tax dollars. How could blue states use the taxes they pay into the Treasury to retaliate?
Every state is an employer and is oftentimes the major employer in any given state. And as with any employer, the state has to withhold money for federal taxes. And in the case of the blue states that we mentioned, it is a substantial amount of money. In fact, as we note in the article, the blue states are net donors. In other words, they give more money to the federal government than they get in the form of services. Now, it would be illegal, and I have to say that quite candidly, for the blue states to withhold federal dollars. In other words, the withholding that you do on your taxes, you withhold for the purpose of turning it over to the federal government at the appropriate time. This would be illegal to withhold it, frankly, until the government makes the allocations among the states equal. It would certainly be illegal, but it is leverage. What we say in the piece is that the government, if they continue to favor red states over blue, will be acting illegally and unconstitutionally. And so we speculate that this is something the blue states could do, although it is illegal.
And California has a ballot issue where voters are already considering this?
Right. There's a ballot issue where the voters are not considering withholding tax dollars. California ballot initiative goes even further. The ballot initiative is to secede from the union, which is extraordinary. It's asking the voters to endorse the idea of secession. It's not clear what legal authority that would have, but that's certainly what California voters are indulging in. Again, both withholding federal tax dollars and obviously seceding from the union are patently illegal. But the notion here is the government is behaving illegally. Were they to punish Massachusetts and California, for example, in favor of the red states, the government is behaving blatantly illegally. And to your question about constitutional crisis, there's no question when the government behaves illegally, citizens have to decide what to do. Citizens have to decide what the appropriate response is. And make no mistake, this government is behaving illegally on numbers of fronts, as numbers of federal courts have found.
Do you think that this is the most serious constitutional crisis we've faced since the Civil War?
I think that that's true. It's one thing to have, the pictures of the southern states defying a constitutional directive to desegregate, requiring troops to be sent to southern states to enforce the prohibition against segregation. That was a confrontation as between a unified federal government and particular states. This is a confrontation between the federal government as a whole, individuals, and a confrontation between the federal government as a whole and the states. It's about to involve almost every aspect of our lives. The federal government is asserting control over universities. The federal government is seeking to control who is in the country and who is not, seeking to control who is a citizen, and flouting the Constitution in numbers of ways. So, this is both the scope of the disobedience, the scope of the violations by the federal government on every front. So, yes, I would call it the most serious constitutional crisis since the Civil War.
It seems like Trump threatens, and it seems like he's winning in a lot of respects because, for example, law firms, the biggest law firms in the country, have decided to give him close to $1 billion in free legal services. And you have universities that have capitulated to his demands. So it seems like there's less fighting back.
Well, I think we're beginning to see something different. And let me make a more general point. So the strength of the United States is not just in representative government, not just having Congress and the president elected by the people, and not just having local governments. The strength of the United States is also having civil society, namely organizations like universities and law firms that are independent of the government, that stand for principles that the government can't control. So what Trump has done is he's taken over the government. We elected him. That was a product of the voters, namely that he has the House of Representatives, the Senate, and the White House. But the judges are supposed to be independent, and the judges have been holding. The judges have reflected that independence. What he is doing is trying to dismantle civil society. And the way you dismantle civil society is you dismantle the universities and you dismantle the law firms, not dismantle exactly, but you sort of try to co-opt the law firms. I think we're seeing a change now. I think there was a certain kind of shock at the beginning of this administration. People didn't quite understand how far he was prepared to go. I think that the firms that have sued the government for its illegal actions, like Wilmer Hale, like Perkins Coie, like the latest one is Sussman Godfrey, the firms that have stood up to the government, I think are going to be the wave of the future. 346 retired federal and state judges have signed on to briefs opposing the government's actions with respect to Perkins Coie. Numbers and numbers of people have signed on from all walks of life to amicus briefs. So the law firms, I think, are beginning to learn a different lesson. And Harvard's example yesterday of standing up to Trump, I think, will forecast other universities doing exactly the same thing. I think that there was a certain amount of shock. Surely he didn't mean to go as far as he went, was the sense. And the answer is yes, he has, and indeed further.
Thanks so much for joining me tonight. That's retired Judge Nancy Gertner, a lecturer at Harvard Law School. You can read her column on the Bloomberg Terminal. It's entitled Trump's Blue State Bias Could Rip the U.S. Apart. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.